Now that the presentations are over, I'd like to invite our discussants to make comments and possibly pose some questions. Our first discussant is Professor Keun-Gwan. Professor Keun-Gwan is a professor of law at the School of Law, Seoul National University. He is a member of the ILC, and he's served as the president of the Korean Society of International Law, and also as a vice president of the Asian Society of International Law. Professor Lee.
Thank you, Judge RHEE, for your kind introduction. Good afternoon, everyone. First of all, I'd like to express my sincere thanks to the co-organizers of this conference, Ministry of Foreign Affairs, Korean Ministry of Foreign Affairs, and ICLS, and the Korean Society of International Law, as represented by President Park Byung-do. It is quite a privilege for me to work as a panelist at this session, chaired by Judge Hyoung. I'm very pleased to have an opportunity to interact with you concerning the work of the International Commission in relation to the law of the sea. President Haidar used the word linkage in his keynote speech delivered this morning. I believe it important to pay more attention to the linkage or interface between the ILC, International Commission, and other international judicial organs such as ICLS and ICJ. My pleasure is all the greater because this session takes place in the presence of an eminent former member of the ILC Commission, Sir Michael. Let me also wish a quick recovery to Professor Keun-Gwan, who was supposed to be here with us on this podium. Before offering my comments on the excellent presentations by Martins and Louis, let me acknowledge the active participation of young and bright students who defied the cold weather to come here. I would like to extend warmest welcome to this group of young people who represent the future of international law. I hope that they will nourish themselves in intellectual, culinary, or other terms at this conference. Right. Well, given the very large active participation of a large number of young students, and first of all, I'd like to introduce our commission, my commission, that's International Commission. So I'd like to talk about the following topics in my discussion. So first of all, the function of the ILC, UN International Commission. And then I'll talk about the sea level rise with particular focus on the final report produced by the commission, by my commission this year. And then I also address the question of piracy and armed robbery at sea. For each topic, Professor SAVADOGO is working as special rapporteur. First, let me talk about the ILC, especially for the benefit of some of the students who are here with us. You can find the normative or legal basis for the creation or for the establishment of International Commission in Article 13 of the UN Charter of the United Nations. So let me quote, "The General Assembly shall initiate studies and make recommendations for the purpose of A, promoting international cooperation in the political field and encouraging," and then comes the key expression, "the progressive development of international law and its codification." Let me repeat this key phrase, the progressive development of international law and its codification. So my commission, the UN International Commission, is created and established exactly for that purpose. And for the more detailed, let's say, working definitions of these two key terms, progressive development of international law and its codification, let me refer you to Article 15 of the Statute of the International Law Commission. So for the benefit of time, I'll just proceed on to the next item. So here, let me just briefly talk about this idea of codification of international law. I'm saying this because this concept of codification has a very long pedigree, and it has a great deal of interest, relevance to the topic we are discussing here. For instance, Martins, in his brilliant presentation, he mentioned this ILC's role for the 1958 Geneva Conventions on the Law of the Sea, right? In that process, it was the ILC, International Law Commission, which prepared the draft conventions. So the 1958 Geneva Conference on the Law of the Sea, operated on draft articles prepared by the ILC. So here, again, this idea of codification has a very long pedigree, which can go back to at least Jeremy Bentham. So Jeremy Bentham, he published a book titled Principles of International Law, which was published in 1789. There he proposes this idea of codification, not just of domestic law. The example would be, of course, 1804, Code de Napoleon, and some other codification work carried out in the former, Holy Roman Empire. But here he was proposing, floating the idea of codifying the rules of international law as well. So there, in that book, he started his discussion by raising the following hypothetical question. I quote, if a citizen of the world had to prepare a universal international code, what would he propose to himself as his subject? End of quote. So again, starting from this idea, one can say that, in the 19th century, during the 19th century, there were quite a number of effort for codification of international law. And they are briefly divided into works of private codification and works of official codification. So when it comes to private codification, the most prominent examples would include the 1868 work done by Johann Caspar Bullincilli. And the title of that book is, it's Modern International Law, but the subtitle is als Rechtsbuch dargestellt, presented as a legal code. So this Johann Caspar Bullincilli, he came up with this book. Is a private codification which reads like a code, starting with Article 1, running Article 600, 700, things like that. And then, of course, here, well, by the way, Martins, congratulations on your election to an associé of the Institut de droit international. There was an Institute of International Law, which was established in 1873. So it engaged in lots of codification work, and it continues its work in that regard. And then when it comes to official codification, well, the most prominent example would be 1899, the first Hague Peace Conference, and 1907. And for our purpose, the 1970 Hague Conference for the Codification of International Law looms very important because 3 topics were dealt with in 1930, and one of them was on the question of territorial sea. Right, so let me just go on to the next topic. That is ILC's work on sea level rise. As a member of the ILC, I'm much pleased that, as was lucidly explained by Martins, the ILC has made a significant contribution to the development of international law, in particular, the law of the sea. It is a well-known fact that the 1958 Geneva Conventions were adopted on the basis of the draft articles prepared by the ILC. If you turn your eyes to the recent developments, the Commission has brought the topic of, I quote, sea level rise in relation to international law, end of quote, to a successful conclusion this year. It is highly gratifying that some conclusions contained in the final report of the Commission on the topic of sea level rise have been endorsed in the advisory opinion of the ICJ. For instance, the court specifically referred to the final report of the study group in paragraph 361 of its advisory opinion on climate change, which was rendered on July 23rd of this year. In the next paragraph, that is paragraph 362, the court went on to hold that, I quote, states parties to UNCLOS are under no obligation to update their charts or lists of geographical coordinates, end of quote, echoing the conclusion contained in the final report of the Commission. I think the contribution of the study group was mainly twofold. First, the work of the study group, well, I think that point was addressed briefly in passing by Martins, and the, let's say, normal mode of method of work within the Commission is for the Commission to prepare draft articles, right? And then the UN General Assembly will convene a diplomatic conference, and they will turn these draft articles into a binding convention. But now, the ILC has come up with some different diversity of working methods, and one of them is study group. And as I think the contribution of the study group was mainly twofold. First, the work of the study group served as a sort of clearinghouse of relevant state practice and views, providing an invaluable source of information on state practice. ICJ recognized this when it observed that, I quote, the final report shows a convergence of views among states across all regions in support of the absence of an obligation of states parties to UNCLOS to update charts or lists of geographical coordinates relating to their maritime zones once they have been duly established in conformity with UNCLOS, end of quote. Secondly, the work of the study group functions as a sort of catalyst for the clarification or formation of rules of international law relating to sea level rise. It is expected that some of the conclusions of the final report will be turned into international treaties or consolidated into the corpus of customary international law. As regards the latter, I just adduced one example, that is the absence of an obligation of state parties to UNCLOS to update charts or lists of geographical coordinates relating to their maritime zones once they have been duly established, as confirmed by the ICJ. Well, in that connection, this morning, there was session one, and in session one, Sir Michael, he addressed this question in some detail, and he talked about the traditional principle of ambulatory baselines. And so he raised some, let's say, questions and concerns relating to this part of the judgment of the ICJ. He didn't refer to the ICJ advisory opinion specifically, but he raised some concerns relating to this. And so for the benefit of a diversity of opinions and views on this question, let me just dare to provide some footnote to his excellent presentation. And first of all, of course, it has to do with treaty interpretation. As you know, paragraph 1 of Article 31 of Vienna Convention on the Law of Treaties, it says that, it provides that a treaty is to be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty, in its context and in light of its object and purpose. So this is very flexible formulation, right? And then let me refer you to a rather important piece of state practice. That is the view or position taken by the United States on this question. So I'm utilizing material provided by the US Indo-Pacific Command. There's a rather very short and concise document, but let me just read out from the relevant part of that document. I quote, "The United States supports the Pacific Islands Forum's declaration, semicolon, recognizes the need for stable maritime zones in the face of sea level rise caused by climate change, semicolon, and is committed to preserving the legitimacy of existing maritime zones and their associated rights and entitlements," end of quote. And a similar position was uttered by the US delegate in the forum of the UN General Assembly 6th Committee as well. So in considering this very important question, I think we need to take into consideration this state practice offered by the US as well. Okay, so the study group will work as a template for the Commission's future work for the progressive development of international law and its codification with respect to the topics that require a prompt and comprehensive responses by the international community, such as sea level rise. And let me just put one question to Martins. So now that the IRC has produced its final report on sea level rise in relation to international law, what would be the more concrete, let's say, follow-up action one can think of? And then let me move on to the next topic, that is piracy and armed robbery at sea. So here, I'm going to raise basically 3 points. First of all, it's more rather general question. So when you deal with piracy, I think we are confronted with a challenge of addressing a fast evolving, fast changing 21st century problem with a largely late 19th century, or at the earliest, the early 20th century regulatory framework as one can find in the UNCLOS. So, and then I'll move on to the next point, that is the pitfall of syncretic conflation of piracy and armed robbery at sea, and then a family resemblance between piracy and the core crimes under international law, with particular reference to the universal jurisdiction. All right, but I think I have just about 3 minutes, so I think I have to speed up a bit. Okay, let me first point out that despite the impression of an ancient and long pedigree created by the expression hostis humani generis, well, if you look at some of the law of the sea textbooks, some people say that this hostis humani generis, that's enemy of the human race, was coined and used even by Cicero, right? So this term, hostis humani generis, in connection with piracy or pirates, it puts you under the impression that this concept has such a long pedigree. The current law, but despite that impression, current law of piracy as codified in UNCLOS is in fact of a fairly modern origin. Until the middle of the 19th century, the Latin expression, hostis humani generis, was largely a rhetorical invective designed to disparage and criticize piracy, rather than serving as the concrete foundation of universal jurisdiction. It was only during the latter half of the 19th century that the institution of universal jurisdiction over piracy was firmly established with a clear definition of piracy. So it is evident that there exists a serious gap between the fundamentally rather outdated 19th century or at most early 20th century regulatory framework on the one hand and the fast evolving 21st century piracy as illustrated by the use of drones, even AI-operated drones by pirates on the other. Here lies the enormity of the task of the Commission is confronted with. And I wish you, all the good luck, best of luck to Louis, who is working as the special rapporteur on this very important topic. So, in this regard, I'd like to draw the attention of the audience to the approach adopted by the Institut de droit international in its Angers Resolution 2023 on piracy. In the preamble to the IDR resolution on piracy, one finds a considérant which alludes to the need for a delicate evaluative interpretation of the relevant provisions of the UNCLOS on piracy. Let me just read out the relevant considérant. That's acknowledging that the provisions on piracy of the 1982 United Nations Convention on the Law of the Sea reflect customary international law, and that such provisions, whenever appropriate, can be interpreted and applied in the light of subsequent international practice and relevant rules of international law, end of quote. Right. And I would like to name this approach the UNCLOS plus approach. So this approach, which I've just named, just called the UNCLOS plus approach, is not something unfamiliar with the Commission. It is based on the notion of evaluative interpretation of treaties, which the Commission addressed in its work on draft conclusions on subsequent agreements and subsequent practice in relation to the interpretation of treaties. So I'll just raise this last point and then wrap up my discussion. And let me just point out the pitfall, the potential pitfall of syncretic conflation of piracy and armed robbery at sea. So in addressing this question of piracy and armed robbery at sea, I would like to emphasize that one needs to bear in mind the fundamental distinction between the high seas where piracy occurs on the one hand, and the territorial, archipelagic, and internal waters where the principle of territorial sovereignty applies to armed robberies committed therein on the other. Eroding this fundamental distinction or conflating these two significantly different categories should be avoided. And in that connection, I'd like to put this question to Louis. My question is, Professor SAVADOGO, how would you plan to address in your work as special rapporteur the distinction, this fundamental distinction between piracy on the one hand and armed robbery at sea on the other? I think I used up my time already, so I'd like to express my sincere thanks to all of you for your kind attention. Thank you.
Thank you, Professor Keun-Gwan, for sharing your very thoughtful reflections on the functions of ILC, especially the codification and also the two topics presented, and making very pertinent questions. Now I'd like to invite Professor MAGNÚSSON to make comments on the topics presented and also possibly pose some questions. Professor Bjarni MAGNÚSSON is a professor and dean of the Department of Law at Bifröst University, Iceland. Professor MAGNÚSSON, the floor is yours.
Thank you very much. Mr. President, ladies and gentlemen, allow me to begin by thanking the organizers of the conference. The conference is outstanding, both in its substantive content and in terms of the excellence of its organization. I am especially grateful and slightly worried to be here for the third time. Either this means that you found my earlier interventions useful, or you are testing the patience of the regular participants of this conference. In any event, I'm truly delighted to join you once more and to participate in this wonderfully crafted session. It is a privilege to serve as a discussant alongside such distinguished colleagues. The law of the sea is often viewed as a rather technical branch of international law, with all sorts of lines, measurements, baselines, maritime zones, and coordinates. The two presentations on this panel, however, remind us that it is anything but a static field. When it comes to developing the law of the sea, specialists in the field should perhaps think of themselves as artists of international law. Our work is creative, but it is a disciplined creativity, operating within a shared language, set of techniques and procedures. The tools of this craft are familiar ones. They include the law-making toolbox in a broad sense: treaty negotiation, institutional practice, judicial and arbitral decisions, and advisory opinions. But crucially, also the interpretive framework of the Vienna Convention on the Law of Treaties. Within that framework, there is room for responsible choice of arguments, for identifying which considerations matter, how far subsequent practice can be taken, and how to read long-standing provisions in light of new scientific knowledge or emerging threats such as sea level rise. In this sense, the law of the sea develops not only through the addition of new treaties and cases, but also through the cumulative interpretive brushstrokes of judges, counsel, diplomats, and scholars who use this common toolbox to adapt an existing architecture to new circumstances while preserving its coherence and legitimacy. Seen in this light, the United Nations has created an extraordinary array of possibilities for the development of international law, not least in the law of the sea through its conferences, institutions, and judicial bodies that provide the principal fora in which this creative legal practice unfolds. Both presentations usefully remind us that the International Law Commission has played and continues to play a central role in the development of the law of the sea, not only through the production of draft articles, but also through its collecting activities of state practice. As the speakers underlined, the ILC has long served as a forum in which often scattered and diverse national practices are gathered, organized, and subjected to careful legal analysis. This was already evident in its work in the 1950s. As Professor PAPARINSKIS showed, the 1956 ILC draft articles concerning the law of the sea still resonate in contemporary case law, illustrating the lasting normative footprint of the work of the ILC. Today, in its consideration of sea level rise, the Commission once again provides an indispensable framework for collecting, comparing, and recording state positions on questions that will shape the future stability of maritime entitlements. I'd like to misuse this opportunity to draw attention to one broader issue concerning state practice, language, and the sources of international law. Before you conclude that I have completely gone off track, let me underline that the point I'm going to make is connected to the themes of our panel and how we understand the development of the law of the sea. As I trust everyone in the room is aware, when we speak of the sources of international law, we usually begin with Article 38 of the Statute of the ICJ, which lists the applicable sources of law, and at the end refers to judicial decisions and the teaching of publicists as subsidiary means for the determination of rules of law. In principle, those judicial decisions may come from any court in the world. In practice, however, it is obvious that parties will not invoke judgments they do not know exist, and scholars will not cite case law that they are not aware of. Decisions written in languages spoken by relatively few people and not translated into any of the more widely used languages are therefore unlikely to have much impact beyond the specific dispute in which they were rendered. They remain, as it were, unnoticed contributions to international law. That has been the fate of the 1922 Icelandic Supreme Court judgment that addresses the impact of changing coastlines on maritime jurisdiction. The changing coastline in this case resulted from a volcanic eruption in 1918. In light of the sand and other materials deposited seaward by a glacial outburst flood triggered by the volcanic eruption, relevant land territory, in this case, had extended seawards by roughly 1 nautical mile. The Supreme Court of Iceland, in its judgment, upheld the interpretation of the Reykjavik Police Court that the territorial sea line was not a fixed or permanently determined line at sea, but one that shifted with avulsions and accretions. So what the Reykjavik Police Court was saying, and the Icelandic Supreme Court supporting, is that the territorial sea baselines are ambulatory in nature and not fixed. I feel confident in saying that this judgment is just one of many other national decisions that raises important and sometimes quite sophisticated questions of international law. Practically speaking, such decisions are not part of the ordinary toolbox of international lawyers. This point raises a much broader set of questions about language and power in the international system and about whose practice and voices shape the content of international law. This also highlights a particular responsibility resting on those scholars who work in and have access to such small language jurisdictions. If important decisions remain locked in Icelandic, Latvian, or any other less widely spoken language, their contribution to state practice will remain largely invisible. So these scholars, in my opinion, have to bring these precedents into the broader conversation of international law. And in this old Icelandic Supreme Court judgment I have been mentioning, we see what might be regarded as the traditional view of the ambulatory and fluctuating nature of baselines. That is, that the land-sea interface moves with physical changes to the coast, and that the maritime zones follow. As Professor PAPARINSKIS has explained, the contemporary law of the sea is, in important respects, moving away from that understanding in the context of sea level rise induced by climate change. And this prompts an open and general question I would like to put to it. Is it still fully accurate to say that the land dominates the sea? Are maritime zones still to be understood simply as the shadows cast by a state's land territory? Or are we witnessing the gradual emergence of a more autonomous conception of maritime entitlements, one that is less tightly tied to the physically shifting coastline? And I would also like to put a very open question to Professor SAVADOGO. So, in his presentation, he described very carefully and illuminating how an important law of the sea issue moves forward within the United Nations and in particular within the ILC. So I was just wondering, in this current global political environment with all sorts of increasing tensions, how do you see these dynamics affecting the capacity of the ILC and other United Nations bodies to contribute to the further development of the law of the sea in these related areas as well as in others? Thank you very much.
Thank you, Professor MAGNÚSSON, for pointing to the importance of judicial decisions and state practice in the development of international law, and also making some significant questions to the speakers. Now I'd like to invite Dr. Sander to discuss the topics. Dr. Omri Sander is a partner and chair of the Public International Law Practice Group at Horowitz and Company, one of the largest law firms in Israel. Dr. Omri Sander, the floor is yours.
Thank you very much, Judge RHEE. And I also thank very much the Korean Ministry of Foreign Affairs, the International Tribunal for the Law of the Sea, the Korean Society of International Law, and all those who put together this remarkable conference that I think has established itself truly as an excellent forum for advancing discourse on the law of the sea. I'm also very grateful to our distinguished speakers, Professor PAPARINSKIS and Professor SAVADOGO, and to my distinguished fellow commentators, Professor Lee and Professor MAGNÚSSON, for their enriching presentations. In my own brief remarks this afternoon, I wish to address more generally our central theme, the contributions of the United Nations to ocean governance. I will make three interconnected observations, and I will close with a question that I have been tempted to ask our panelists, having listened to them with great attention. My first observation, one which I think deserves both emphasis and consideration, is that the UN's work on ocean governance represents one of the organization's great successes. Since its founding 80 years ago, the UN has maintained consistent leadership on ocean issues and remains the preeminent actor in this domain. It is one actor with an overarching role that can help to ensure the unity of the law of the sea. Together with the Secretary General's annual report on the law of the sea, the General Assembly's annual debate and annual resolution ensure that the law of the sea is kept under constant review. Even when ocean-related initiatives emerge from discussions elsewhere, they often find their way to and achieve resolution in the United Nations framework. The successful negotiation of the BB&J agreement most recently deserves special mention in this regard. The UN's institutional architecture for ocean governance is remarkably comprehensive, reflecting the multidimensional nature of maritime challenges. These challenges span a vast spectrum, from economic and social development through food security, climate change and trade, to communication and international peace and security. The UN itself has long recognized that sustainable ocean use requires a coherent management approach across all sectors of human activity affecting our seas. As President Haider and Judge RHEE have recalled, and others today, the UN's multi-layered institutional framework for ocean governance encompasses numerous bodies and mechanisms. The General Assembly stands at the apex, maintaining close and constant review of ocean issues, examining the full spectrum annually, and taking concrete steps to address emerging challenges. Then there are the subsidiary bodies and programs of the General Assembly, including the open-ended consultative process on oceans and the law of the sea, and, as our speakers have demonstrated, the International Law Commission. The UN Secretariat, including the Office of Legal Affairs with its Division for Ocean Affairs and the Law of the Sea, provide essential ongoing input and support. Its role in relation to the Commission on the limits of the continental shelf deserves special mention. There are also the International Seabed Authority, the Secretary General's Special Envoy for the Ocean, and the involvement of organs such as the Economic and Social Council or the Commission on Sustainable Development. There are also, as has been recalled, the UN Environment Programme and the UN Development Programme. Of course, the Security Council and the International Court of Justice have long provided critical input, as have multiple other UN-affiliated organizations, including specialized agencies. It's a long list, and I think it's important to just realize just how expansive the treatment of the law of the sea is within the United Nations system. This engagement with ocean issues through these various organs involves comprehensive governance processes. First, there's an ongoing assessment of the marine environment, formulation of rules and standards, decision-making, implementation efforts, and constant monitoring and evaluation of these efforts. This work involves extensive collaboration with multiple stakeholders, both in the public and private domain, and ensures broad participation and buy-in. One important point to take away is that despite the dispersed nature of international ocean governance and the inevitable overlap in mission and focus, the challenges of turf wars and inconsistency have largely been avoided. Instead, ocean governance has been an area of remarkable interinstitutional convergence and cooperation, one of collegiality, consistency, and harmony. In this, the Secretariat and the General Assembly have played a major role. Therefore, for example, the ILC has been elaborating law of the sea instruments through the traditional engagement with the Sixth Committee, while the General Assembly pursues its own direct work on such lawmaking instruments. The ICJ and ICLS, as President Haider reminded us, have shown great respect for the output of one another, operating in tandem to ensure consistency in the law and the jurisprudence. The ICJ has quite readily, perhaps too readily at times, adopted the positions of the ILC and vice versa, including, as we've just heard, as regards sea level rise. Interestingly, organizations predating UNCLOS swiftly adapted their frameworks to ensure compatibility with the convention. And legal instruments have coexisted harmoniously with non-binding resolutions and declarations, as well as the Sustainable Development Goals, particularly SDG 14 on ocean conservation and sustainable use. This is not to say that serious implementation gaps do not remain or that urgent action is no longer required. Alongside the procedural successes, there have been substantive failures as ocean health indicators continue to remind us all. Some advocate for enhanced General Assembly oversight, but such initiatives must, of course, respect the Charter's clear division of powers. In any event, there is growing momentum toward comprehensive rather than sectoral approaches and improved coordination among the existing structures. The establishment of UN Oceans in 2003 as an interagency coordination mechanism with strengthened mandate a decade later exemplifies this coordination effort. The international community's consistent reliance on the UN for global ocean governance should not be taken for granted. One important question, though surely not one for the lawyers alone, is why it is that the UN has achieved such remarkable success in ocean governance compared to other global challenges. While the oceans clearly represent a common good requiring global cooperation, so do other issues that have proven more intractable. Understanding this success may yield valuable lessons for addressing other global challenges, and I urge us all to think about that. It is helpful in this regard also to appreciate what has not happened over the last 80 years. No major maritime conflicts between states since UNCLOS, though of course there are some critical areas of tension. The peaceful resolution of numerous maritime boundary disputes through UN mechanisms, and the avoidance of tragedy of the commons scenarios that were predicted by scholars in the 1960s. What is more, the UN ocean governance achievements have not only demonstrated that complex, multi-stakeholder challenges can be resolved through international negotiation and cooperation, they've also enabled coordination at the critical regional and national levels. Even more than that, the successes have resonated far beyond the maritime domain and indeed beyond the UN itself. As the UN Secretary General Boutros Ghali observed in 1993 in relation to the work on the law of the sea, these successes have been an essential stage in the building of a real community of nations. My second and related point concerns the law of the sea more specifically, and the fact that, as we've been reminded today, the primary legal instruments governing the oceans have all originated in the UN. UNCLOS in particular represents one of the most successful international treaties ever negotiated, establishing a legal order that facilitates international cooperation, peaceful uses of the seas, and equitable utilization of their resources. It encompasses a vast array of human activities, and as we've heard, it provides stability and certainty while at the same time allowing for dynamism and development. The development and adoption of UNCLOS within the UN and the organization's role in monitoring and promoting it have generated a gravitational pull toward a unified legal framework for all member states. Given that a significant number of states with major maritime interests are still not parties to UNCLOS, customary international law, which in principle binds all states, has remained a central means of bringing under one legal roof all those states, including those non-parties. If treaties can codify existing rules of customary international law, crystallize emergent rules of customary international law, or generate new rules of customary international law, then UNCLOS has done all three. The ICJ had remarkably looked to UNCLOS in determining customary international law even before the convention entered into force, and over the years it has found many of its provisions to reflect existing customary international law, as have ICLOS and other tribunals. Indeed, the ICJ declined to decide otherwise, even when faced with significant evidence of state practice that was inconsistent with the rule laid down in the convention. In alleged violations, for example, the court held that Article 33 of UNCLOS reflected contemporary customary international law on the contiguous zone, finding that the materials adduced by Colombia with regard to the legislation of several states did not support the claim that the customary rules on the contiguous zone had evolved since the adoption of the convention. In territorial and maritime dispute, the court similarly found customary international law to be reflected in the convention, notwithstanding state practice that was contradictory in regard to Article 121, Paragraph 3 of the convention, which prescribes that rocks shall have no exclusive economic zone or continental shelf. The inclination, almost natural inclination, to affirm the existence of customary international law is further evident in the court's more recent judgment on delimitation of the continental shelf beyond 200 nautical miles and its advisory opinion on climate change. The gravitational pull towards general international law no doubt brings substantial benefits and is reinforced by UNCLOS's near universal membership. All the same, and I say this with due care, international law has always accommodated diversity within unity, and the UN itself serves as an essential forum where this balance is both contested and preserved. And this is another point worth bearing in mind going forward. A third and final point is this. Any assessment of UN ocean governance must be viewed through the lens of the organization's basic and fundamental mandate of maintaining international peace and security. To quote Secretary General Boutros-Ghali once more, peace and justice are at stake on the seas too. Here, the threats of piracy, maritime terrorism, and the trafficking in arms, drugs, and humans come readily to mind. Critical maritime zones such as the South China Sea, the Eastern Mediterranean, and the rapidly changing Arctic serve as potential flashpoints. The UN's success in ocean governance ought to be measured while bearing in mind the organization's action or inaction in the face of these and related challenges. And it seems particularly fitting and important to stress this in today's challenging times. I close with a question to our distinguished panelists as regards sea level rise. And the question I had while listening to the very informative and rich presentation was whether it is state practice that we have before us to take into account, or whether when we discuss these statements by states, is it not more of a nascent expression of opinio juris, or expression of nascent opinio juris as opposed to state practice? And in any event, is it state practice in the sense of customary international law, or is it state practice in the sense of subsequent practice, at least as regards those states that are parties to UNCLOS? With that, I thank you for your attention, and I'll close.
Thank you, Dr. Sander, for the overall assessment of the institutional mechanism of the United Nations and also the jurisprudence of international courts and tribunals. So we have about 20 minutes left, and before opening the floor to the audience, I'd like to give the speakers the opportunity to respond to the questions or comments made by the discussants. So, Professor PAPARINSKIS.
Thank you, Judge RHEE. Professor Lee Dear Keun-Gwan asked about where to go onwards from where we are now, so that we have the final report of the study group in Annex 1. What happens after that? Well, to some extent, the last 3 paragraphs of the report already contain the roadmap that, in the view of the Commission itself, in the view of the Commission adopting the report of the study group, should be the way forward. That is the title of the subsection, Possible Ways Forward, where the report says the following approaches, individually combined, may be considered by states, international organizations, and other relevant actors in developing practicable solutions to effectively address the international legal issues arising from climate change-induced sea level rise. And if you recall, sort of somewhere about 3/4 in my PowerPoint, there were the 2 slides, one interpretation of existing instruments, and the other one adoption of new instruments. So ILC has already pitched at hand what can be done. But perhaps going one step further, slightly more concretely, well, I think one direction would be conduct, broadly speaking, within international universal organizations such as the United Nations. Of great importance were the reactions by states in the Sixth Committee. Keun-Gwan quoted the language of the United States, so that was states were very interested in the topic, indeed, to the extent that, I think to a considerable extent, reactions specifically on the sea level rise meant that this committee twice overran its allocated time in engaging with the ILC work. I will not try to summarize the richness of reactions, perhaps only to note the point of the call for importance for a careful read of states' reactions, because I have seen perhaps in some scholarly overview of states' engagement a tendency to unduly flatten the normative landscape. States approach these matters very carefully. Within the ILC, we read with great care the language and qualifications that states use. So states sometimes speak in terms of law, sometimes they speak in terms of policy preference. And recall the language quoted by Keun-Gwan. United States spoke a lot about policy. United States spoke about a lot of desirable outcomes. It said what it would not do. It called upon other people to do things. It did not necessarily express a view on positive, applicable international law. And that is a perfectly fine position for a state to take. Other states have taken different positions. Other states have taken different legal positions or perhaps the same position for different legal rationales. It is just to say that there is already a great deal of rich and interesting state practice out there that needs to be read with care. There are other things that may happen. Next year, the high-level panel will convene on issues of sea level rise. That was why it was so important for the International Law Commission to conclude its work on sea level rise this year, so that next year the General Assembly could build on its basis. So some of you may be aware of the lively discussion last year about the precise way how International Law Commission and General Assembly work interacts on these issues. So that is one direction of development. There are directions of development in the context of perhaps specific resolutions being adopted on the matter. There may be developments in the regional setting. So it is my understanding that Pacific Island Forum, that has been very influential in the developments on issues of maritime boundaries and statehood, is reflecting on the possibility next year of debating another declaration on persons and statelessness. And of course, these are matters that could, as it were, emerge through the normal workings of international law. When and if issues arise before international courts and tribunals, states may choose to adopt, whether explicitly or by necessary implication, positions that are set out by ILC in its work. So that is how I would view positions moving forwards. Things taking place universally, things taking place regionally, and things taking place in the normal workings of international law, where states will, when they find it useful, build on the language and solutions of ILC. Bjarni raised the question about land dominates the sea, and he also called, rightly in my view, for greater engagement with less obvious sources. This is actually something that the International Law Commission is very sensitive to. In the current work on subsidiary means for determination of rules of international law, in draft conclusion 8, as adopted in the first reading, linguistic diversity is singled out as one consideration in evaluating the weight to be given to materials. So I think that that is certainly a point very much reinforced by the multilingual environment of the ILC, where there's a sense that it would be terribly parochial to rely only on materials in English. That would not be a done thing. And of course, good practice, in my view, and again entirely agreeing with the question, is to apply the principle not only to large states, but also to smaller states. Now, possibly a technical legal answer to the puzzle of the 1922 Icelandic judgment is the question whether it was known to other states. That is a question that commentary 5 to conclusion 5 of the 2018 ILC conclusions on customary international law says. For customary international law to be formed, other states need to know about practice. And so I think it's an objective question whether or not they knew about it. And of course, there are examples, one might say, from small Nordic states and domestic court judgments just in the last week that have been flagged that plainly sometimes these judgments are known. So there's great potential there. Now, land dominates the sea. This was something that was a subject of lively discussion in the International Law Commission in 2023, and as you can see in the summary, there was a variety of views expressed by members of the Commission. It is interesting that in the final consolidated report, the co-chairs of the study group note the reactions by states to that discussion. And overall, states are open to the idea that land dominates the sea needs to be applied with a degree of flexibility. So let me just note a couple of examples. Greece added that concepts such as the principle that the land dominates the sea must be examined in the light of the principle of stability of boundaries. And the need to preserve baselines and outer limits of maritime zones. China supported the view expressed by the co-chairs that the principle that the land dominates the sea should not be rigidly applied. The Russian Federation expressed a similar view. The European Union and its member states noted that while the principle that the land dominates the sea was an underlying premise for the attribution of maritime zones, it did not necessarily imply that coastal states would be legally obliged to periodically review or update the relevant charts and coordinates. And I think perhaps the expression of underlying premise or organizing maxim might be the one that captures best where International Law Commission was on the issue. A descriptively useful proposition, but that is not something that would replace the analysis of the precise applicable rules. At the same time, to answer the question squarely, in my view, that we are still within the same paradigm, because the legal solution provided by the International Law Commission operates in adjusting the juridical conception of baselines, rather than proceeding in a completely different direction. Omri's questions, as always, strike at the very heart of the hard issues. So the practice expressed verbally, particularly but not exclusively in the Sixth Committee, played considerable role in the discussion in the International Law Commission. So Omri asked two questions. Whether that is state practice at all or something closer to perhaps a proposition of a desirable opinion on the legal rule. I think that within the ILC, I think that there's a broad sense that state practice in the modern setting is not limited to physical acts, but verbal acts such as statements and declarations adopted may also count as state practice. Whether they count as opinio juris as well depends on the legal rationale. And as I said, that goes to the point that I made in reacting to Keun-Gwan's questions. Sometimes these statements express opinio juris, sometimes they do not. That is an answer to be provided rather than a general sweeping a priori characterization. But broadly, in many respects, it was viewed as reflecting a sense of legal relevance. The second question is whether that was state practice for the purposes of customary international law. Here it is worth noting that within the International Court of Justice, the language relates to interpretation of UNCLOS. So I think that is one point to be noted. The other point is that, at least within my time on the International Law Commission, the discussion was predominantly conducted in terms of interpretation of a treaty instrument. And it seems that the language that may have existed elsewhere earlier in relation to customary international law has gradually faded into the background of some states expressing the view in the discussion that that might be a less helpful intellectual framework. Now, there are interesting legal and tactical reasons for preferring one source for articulating arguments rather than the other, but I will leave that discussion for another occasion.
Thank you, Professor PAPARINSKIS. So, Professor SAVADOGO, please take the floor.
Thank you, Mr. President. I will answer, first of all, a question raised by Professor Lee concerning the distinction between armed robbery at sea and piracy. The difference is not a difference of substance. It is a difference based on the place, on the maritime zone where these illegal activities occur. High seas for piracy, internal waters, archipelagic waters, and territorial sea as far as armed robbery is concerned. I would also want to add that armed robbery is not treated in the convention. It is a notion which has been created more recently, but taken by many international texts, including some binding texts, such as the agreement concluded by the ASEAN countries concerning combating piracy, the African Charter of Maritime Security. Well, there are other international texts using the term armed robbery, but they're not mandatory. The Code of Conduct of Djibouti, now the Code of Conduct of Jeddah, and the Code of Conduct of Yaoundé. Now, there is a legal consequence. As far as piracy is concerned, according to Article 105 of the Convention, there is universal jurisdiction, which is totally different from armed robbery occurring in waters under jurisdiction, which entails the competence of national courts, not international not universal jurisdiction. Regarding how to proceed, the question posed by Professor MAGNÚSSON concerning how the International Law Commission is going to proceed in order to avoid criticism concerning the way to draft the new text, the new articles concerning piracy. In the Commission, we already decided to remain in the framework of the Convention. And at the last week of international law, states in their statement concerning armed robbery at sea and piracy, they invited the Commission to remain in the framework of the Convention, and will do so. We are very careful. Well, I don't have anything else to add in this regard. Thank you, Mr. President.
Thank you, Professor SAVADOGO. Professor Lee, you would like to make some further comments? Okay, go ahead.
Thank you. Thank you, Judge RHEE, for giving me the floor. Well, first of all, I'd like to extend my sincere thanks to our panel. And, well, I'd like to address the question raised by Bjarni concerning this 1922 Iceland Supreme Court judgment, right? And I think in the first session, I think it was Natalie who mentioned, I think it was in connection with the with Article 58, due regard. And in addressing that question, she used the expression context dependent. So I think we can apply that notion to our discussion. So when it comes to your case, right, there was a volcanic eruption, and then there was extension of the, let's say, coastline, seaward. Then in that case, I think you have to adjust your maybe nautical chart in accordance with the physical change, right? Otherwise, it'll pose a huge hazard to the navigations and things like that. But when it comes to sea level rise, well, again, when it comes to that question, I think we need to maybe take into consideration the specific context, right? So I think the question becomes a bit more delicate, in my opinion. So when it comes to this question, well, within the commission itself, study group, we talked about this, okay? If there is a discrepancy, as it were, between the physical reality on the one hand and the nautical chart deposited on the other, then wouldn't it cause hazards for navigation? Well, in that context, well, according to one opinion, I think nautical charts submitted by states to depict baselines and unclos, they are deposited for the purpose of, it serves a legal function to demarcate maritime zones, while, in contrast, actual or operational navigation relies on updated hydrographic surveys and real-time data. So that we can finesse, in a way, there's two different questions, in my opinion. And then the second one goes to the point, very important point. Well, even though here we are dealing with the question of, seemingly technical question of the law of the sea, but at the same time, as international lawyers, we can't avoid tackling the fundamental question of customary international law, as was pointed out by Omri and as elaborated by Martins. Right, okay. So I'm sure that we can spend at least two-day conference, devote two-day conference to this topic without reaching any consensus we can live with. But at the same time, let me just point out, right, okay, so maybe US has just just as a policy consideration, but at the same time, given the context, again, here we need to take into consideration the actual circumstances and context as well, right? So the US changed its position in 2022. So, so it was just 3 years ago, they changed their position from basically, ambulatory position to this. And then the statement was made in the context of the, of course, UN General Assembly Sixth Committee meeting, and then some other important documents. So probably we need to take into consideration these as well. And concerning, going back to the question raised by Omri, I think it has more to do with the state practice concerning the formation of customary rules of international law rather than subsequent agreement. Because if you look at the UNCLOS itself, there aren't quite clear provisions concerning addressing this problem. So I'm inclined to this view. Okay, thank you.
Thank you, Professor Lee. And now I'd like to open the floor to the audience. Please identify yourself and specify the panelist to whom the question is posed. Judge Kitty Chaisari.
Thank you. Two questions of facts. The first one to Martin. In the final consolidated report of the co-chair, I'm not talking about the final report of the ILC as such, but in the consolidated final report of the co-chair of study group, the last paragraph refers to the need to ask to let ICLS ICJ decide on issues sea rise. But in the final report, ILC itself, this paragraph has been omitted. I wonder what's the rationale behind that, because I used to be a member of ILC. I understand how the drafting committee proceeds, and then this is a very crucial issue. Instead of leaving international courts and tribunals to settle the issues, the ILC leave it to states to consider the outcome of the ILC report. That's my first question. The second question to Luis. You mentioned piracy and universal jurisdiction. I was responsible for the topic, the obligation to extradite or prosecute RHEE adjudicare at the time with a lot of constructive and destructive contributions from Michael Woods at the time. So my point here is that if piracy is subject to universal jurisdiction, why don't you just link it to the obligation to extradite or prosecute? You mentioned briefly about RHEE adjudicare, but what has been the problem for you to go further to automatically linkage between the two universal jurisdiction and then obligation to extradite, prosecute? Thank you.
Can you take a couple more questions? Okay, over there, the lady.
Thank you, panel, for all your speeches that were really comprehensive. You have mentioned the ILC's important contribution in codifying international law and its need to do so. The limitations that we face today, for example, in regards to tackling acts of piracy with a framework that seems unfit given the increasing usage of AI drones especially. And finally, the necessity, the importance to codify international law since as far back as the 18th century. And considering how some international treaties may be perceived as constitutions or mere international treaties, and how most provisions of, say, the UN clause are considered as customary, and the growing concern over how, where, and to what extent the law of the sea should be applied. My question to everyone on this panel is the following: to what extent do you believe that the law of the sea faces political obstacles preventing further codification or progressive development of this law of the sea, and how might the ILC or states overcome such obstacles? Thank you.
Anyone else?
Good afternoon. My name is Bryn Isaac. I'm representing the Philippine International Law of the Sea Academy in alignment with the Konrad Adenauer Stiftung Rule of Law Program Asia. So I have two questions. The first one is for Professor PAPARINSKIS, and the second one is for Professor SAVADOGO. So the first question is, given the complexity of modern maritime challenges, is the current structure of UN bodies sufficient, or is there a need for a new specialized international judicial or regulatory body for ocean governance? And the second question, this one is for Professor SAVADOGO. Given the difficulties in securing domestic prosecutions, what specific role could international judicial bodies or a specialized tribunal play in prosecuting maritime crimes? And what mechanism would be required to grant it jurisdiction? Thank you so much.
Thank you. So, okay, final one.
Hi, Eran Stoger. I'm a practitioner and also a lecturer at Columbia University in New York. And this question is for Martins, but then also anyone else who would like to chime in, noting there are 3 ILC members on the panel. The ILC very early on abandoned its attempt to distinguish between its work on progressive development and codification. Nevertheless, in the context of sea level rise, noting 2 things. One, the way forward. So on the one hand, interpretation of existing bodies of law, treaties, and sources, which implies that it's part of existing law. And on the other hand, subsequent agreements or binding and non-binding resolutions, which implies that it's progressive development. So I was hoping you can address that. And then to add to that, the second element, Martin, as you mentioned, in this case, it was an unusual setup in terms of a study group and a final report as opposed to conclusions and commentary. And I'm wondering in this setup, if it's not a little more ambiguous, whether it's progressive development or codification, as opposed to a conclusion with a commentary, which at least perhaps allows the reader to make that determination. And so I'm wondering for the ILC members how they viewed their own work in this context.
Okay, Professor PAPARINSKIS.
Thank you, Judge RHEE. I have 4 questions. The first was Judge Hyoung raised the question that the draft final report referred to a possibility of submitting requests for advisory opinions, and the final report does not, and that is correct. It will be up to the readers to form a view on the persuasiveness of that choice. I think one methodological difference between the way how this issue is formulated in the final report is that it introduces the sub-sections on interpretation of existing instruments and development of new instruments. And once one makes that analytical distinction, one may conclude that submission of requests to international courts and tribunals is neither of those. So let me leave it at that slightly cryptic point. The second question was whether there are particular political obstacles for development of international law on the issue. And I would probably, you know, it's like turtles, it's politics all the way down, articulated in appropriate legal terms. And if we go back to the first ILC foray in the area, plainly claims about continental shelf and fisheries were made in an intensely political context, but that is the task of bodies for development and codification and adjudication to be able to review these claims against legal benchmarks. So I do not see anything particularly unusual in this setting. Then there was a question about the need for a specialized judicial body for addressing these matters. And I think I would probably tend to be both pragmatically and normatively inclined to view the bodies that we have at the moment as very competent in taking care of these matters. Outside Europe, I don't think that this is a century for new international courts and tribunals. Aaron asked one of the grand questions, again, one of those that one might have a two-day conference on progressive development and codification. I think really I have expressed that view on multiple occasions. I think that the distinction may be communicated not only by using the specific nomenclature, but also by relying or not relying on the type of arguments. If one is making an argument about codification, which may or may not be persuasive, there is a certain type of argument like state practice and opinio juris that one relies on, which is a different one from where one makes an argument for progressive development. And to the extent that these work sort of refers back to the work in the issues paper and elsewhere, so it was quite carefully done that the subsections and sections footnote back to work on which they are based. That would be the way to determine the type of claims that are made. But I think it's objectively also the point to be made that methodologically speaking, each of these three subfields raises a different sort of challenge. A question of, and some of them may be more easily viewed as answerable in terms of codification. So whether one is or is not persuaded by the position that ILC took on the law of the sea issue, that seems to me an issue that is eminently capable of being answered in these terms. The issue of statehood, where state practice and articulations of legal positions at an early stage may be a harder one, and I think in that sense, I think that ICJ captures very well the flux through which the developments move, and Judge Tomka's challenging his declaration, where entirely properly put, shows how this is not an question that it would be helpful at this stage to answer in these terms rather than setting out the framework. So it seems to me that a carefully read final study group report, if accompanied by other relevant materials that I identified in my statement, would enable a sophisticated reader to make up their minds on the type of claim that ILC is purporting to be made. Of course, as I said, without prejudice to whether one is persuaded. As the last 10 seconds, if I may ask for the indulgence, I realize that I did not name the wonderful, wonderful co-chairs of the study group who have done so much. Let me just say before concluding, Nilüfer Oral, Patricia Galvão-Teles, Juan José Ruda Santolaria, and Judge Orescu. I think really the role of individuals in legal changes exemplified very well by these names. Thank you.
Thank you, Professor PAPARINSKIS. Professor SAVADOGO.
Thank you, Mr. President. I first answer the question concerning the role of jurisdiction, international jurisdictions, in prosecuting pirates. The international jurisdictions, such as the International Court of Justice or the International Tribunal for the Law of the Sea, don't have criminal jurisdiction, so they can't prosecute pirates. They can interpret or implement text relating to piracy, but criminal jurisdiction, no. When the statute of the International Criminal Court was considered, when it was drafted, it was considered to insert in the statute a provision giving jurisdiction to the International Criminal Court. Finally, it didn't happen. At the beginning of the years 2010, 2012, there was a project to create an international criminal court specialized in prosecuting pirates. The project failed. I think that taking into account the current liquidity crisis in the United Nations, this kind of project doesn't have any chance to succeed. After telling that, as I mentioned in my presentation, the African Court of Human Rights, to my knowledge, it is the only court, regional court, which has jurisdiction to prosecute directly pirates. Other regional courts of human rights, such as the American one or the European one, may be saved of questions regarding the violation, the alleged violation of human rights of pirates. The second question concerns, I think, the relations between universal jurisdiction and the rule obligation to prosecute or extradite. Well, the universal jurisdiction put a state under obligation to prosecute a pirate. But in certain cases, the state doesn't have the structure or the means to prosecute persons arrested under charges of act of piracy. This is the case, well, the situation is improving, but for a long time this was the case of Somalia. Pirates arrested in Somalia was transferred to countries like Kenya, Tanzania, or the Seychelles. And up to date, most of the pirates prosecuted in these three countries, in Seychelles, Mauritius, or Kenya, they are arrested by, actions of international police, and then transferred to these countries based on international agreements. For reasons, well, obvious, those arresting the pirates don't want to prosecute them and keep them in jail in their own country. It is a reason why, well, agreements has been concluded in this regard. Well, but I agree that this question has to be addressed more deeply. Thank you.
Yes, we are already past time by 6 minutes, but I would like to give just 1 minute to each discussant, if you wish.
Well, unfortunately, I wish.
Okay.
Well, sorry for taking the floor again, but there was a very relevant question raised by some of the participants. So first of all, let me go back to the question raised by Judge Hyoung. Well, I forgot to mention that you served as an eminent member of the ILC. I'm sorry about my negligence. And well, returning to your question, the reason why this, let's say, mention of reference to the ICLS or ICJ was dropped at the last moment, well, it's rather mundane. So we, the Commission, devoted a very long time discussing all these questions. And then if, you know, after all that work, we say that, okay, the final say lies with the judicial organs. That's rather anticlimactic, right? So, we would, no offense, we are not, we of course respect this authority of all the judicial organs, but it was rather mundane. Let me put it that way, okay? But thank you very much for keenly following the work of the ILC. Thank you very much. And then there was a point raised by a student, and I think it was how to, let's say, advance the, let's say, cause of international law and law of the sea by addressing this political obstacles. Well, let me just briefly address that question. Well, that's one way, right? To put power, politics on the one end and law and norms on the other in oppositional terms or relations. But at the same time, quite often, it doesn't work that way, right? So sometimes they work together. Law and politics, law and power work together, mutually reinforcing. Sometimes you have to cajole power or politics to be aligned with norms. But sometimes, in certain circumstances, law feels a bit. I just ask you to finesse the relationship between power and law that way. Okay, thank you. Sorry about that.
Professor Magnuson, you'd like to? Okay, Dr. Sender? No?
Tempted to say just a few words about this question of lawmaking and advancing the law of the sea in the current circumstance. And I think, as always, in these times and in the past and certainly in the future, it's a matter of good faith negotiation, careful consideration of the interests at play, faithful application of the methodology for determining what are the rules of customary international law, general international law, and what are not. And this relates to this issue of distinction between codification and progressive development. The Commission has gained a whole lot by avoiding the distinction, and I think it was wise to do so on various occasions. But I would say that where we have a very clear disagreement among states as regards the states of the law, the intellectually honest thing to do would be to clarify what is the law and to defend a position as regards its progressive development that states as lawmakers will or will not go with. That's it for me. Thank you.
Okay, well, I would like to express my sincere gratitude to our excellent panelists and also to you for your active participation and very kind attention. This concludes this session today. Thank you.
Thank you very much. And once again, please, a big round of applause for Judge RHEE for moderating the second session. And let us give a big round of applause for all the speakers and for all the participants on the floor.